A judge has ruled that Donald Trump and his two of his children, Donald Jr. and Ivanka, must testify under oath in a New York State investigation into their business practices. This is a civil investigation being conducted by the New York State Attorney General, and the judge ruled that the Trumps, they were subpoenaed in December. They must comply with that subpoena within 21 days. There's every indication from lawyers for Donald Trump and for Don Jr. and Ivanka that they will appeal this ruling, and that could take some time. That could really protract things. They eventually want to stave off the possibility that their clients have to testify. And at a hearing that preceded the ruling on Thursday, those lawyers indicated that they would be appealing. So while Judge Arthur Engoron in New York State said that the Trumps must comply, must testify within 21 days, the appeal is probably going to drag that out for some time. Lawyers for the Trumps, for the former president, and for his two adult children, Don Jr. and Ivanka, they argued that this testimony that they are being subpoenaed for could be used against them in a parallel criminal investigation being conducted by the Manhattan District Attorney's Office. Now, that's the investigation that last year led to criminal charges against Trump Organization Chief Financial Officer Alan Weisselberg, and also the Trump Organization itself. Those charges allege that the extra benefits, untaxed benefits, were passed from the company to that executive, Alan Weisselberg. They've pleaded not guilty. Now that investigation is continuing, and the Trumps, their lawyers say that something they might say to the Attorney General's office in a civil investigation that could end in a lawsuit or some penalties, that sort of thing, could then be transmitted over to the district attorney's office and jam them up with criminal liability. Now, of course, anyone giving a deposition, anyone testifying can plead the Fifth Amendment, their right to remain silent, the right to not incriminate yourself in your testimony. But lawyers for the Trumps argued that that could complicate things nevertheless. If Donald Trump, for example, were charged with a crime, potential jurors would probably have some awareness of this whole fight over his testimony. And, with that news splashed across front pages and websites and phone alerts, that lawyer says it would be impossible to get a fair trial for Donald Trump because jurors would think that maybe he had something to hide if he invoked that Fifth Amendment right. Donald Trump hasn't always been a proponent of the Fifth Amendment. In his campaign in 2016, he said the Fifth Amendment is something that people who are associated with the mob would invoke, and that if you're innocent, why would you need to exercise that right? Of course, it's a constitutional right. Everyone has the right to invoke the Fifth Amendment. But Donald Trump, of course, on the campaign trail has said a lot of things and made a lot of critical comments about various factions of life. For example, his opponent in that race, Hillary Clinton, she had some aides who had invoked the Fifth Amendment. He was critical of them. In this case, however, if there is potential wrongdoing, he has every right to go into that deposition if he is ordered on appeal to go into that deposition and invoke his Fifth Amendment right to not incriminate himself.